Okay, Assalamualaikum warahmatullahi wabarakatuh once again. Today we are going to continue with our lecture on the topic damages in personal injury, the second part. In the previous part, okay, we covered general damages, pain and suffering, loss of amenities, mental anguish, and the injury itself. And we had a look at the compendium, okay, how to assess the amount, the compensation. So for today, the focus is on LOFE, loss of future earning, especially how to ascertain, okay, how to determine multiplicand and multiplier. That's basically the way to calculate LOFE. All right. So first we want to get to know what is meant by LOFE, loss of future earning. Actually, it is covered under Civil Law Act. Okay, I'm going to show it to you after this. So basically the rule is that LOFE, loss of future earning, it is awarded when the plaintiff, this is the main, the basis, okay, of the award that you must remember, or you must be clear. It is awarded, it is allowed, it is given, okay, by the court when the plaintiff cannot work at all, okay, after the accident. If the plaintiff can still work, then it will be different. It won't fall under loss of future earning because there is still earning in the future. And then how to calculate? Okay, we have this multiplier approach. And how do we know? Okay, actually we take it from section 28A to D, and it provides the calculation. So essentially, how to calculate, we need to identify multiplicand, and it has to be timed with multiplier. Okay, I'm showing to you section 28A to D of Civil Law. Yeah, I'm resharing to show to you Civil Law Act. All right, so this is Civil Law Act, section 28A, okay, here. So we are zooming into 2D. Okay, this is 2, A, B, C, D. All right, you will see it has 1 and 2 and 3 clauses, Roman here. D. Okay, now we focus on D. I hope it is clear enough. All right, now it's bigger. In assessing, in calculating damages, okay, compensation for loss of future earnings, LOFE. So what is the duty of the court? Okay, the court shall, okay, the court must take into account that, okay, first we look at the age, okay, how old is the plaintiff. In the case of a person who was of the age of 30 years or below, meaning 30 or 29 or 28 or even younger, okay, at the time when he was injured, when the accident occurred. So it is automatic. So it's quite straightforward. The number of years purchased, so that's the term, years purchased. Okay, we are talking about multiplier. Okay, years purchased, it shall be automatically 16. Okay, no need to calculate further. Okay, don't ask me why 16, madam. Okay, there must be reason behind it. Okay, 16. And then let's say, what if the person is above 30, is 31, 32, 33, okay? How to calculate? Is it 16? No, it is not. It will be lower, okay? Lower than 16, smaller than 16. So in the case of any other person who was at the age range, okay, the range is between 31, okay, until the maximum is 59, okay? Why is 59? Okay, that's the retirement age. Okay, before the law was amended in 2019, the maximum is 55. Now it has been amended and now it becomes 59. So the number of your purchase shall be calculated by using the figure 60. Okay, 60, and then minus the age of the person at the time when he was injured, and dividing the remainder by the figure 2, meaning that, for example, the age is 40. Okay, so 60 minus 40 divided by 2. Then you have the multiplier. So you have to do a simple calculation here. As compared to the person, okay, the victim, the claimant, who is 30 or below, then automatically no need to calculate. Okay, no need to count. It's just 16. Okay. But if he is older, okay, more than 30 years old, then this is the calculation. This is to determine, okay, multiplier. We haven't come to multiplicand yet. This is multiplier. ER, okay, multiplier. So it refers to number, okay, the age. Okay, we go back to our slide. Okay, so we were here, right? Okay. Okay, now we are still discussing, we are still on this multiplicand and multiplier. This is the further explanation. Okay, we know the multiplier now. So what is then multiplicand? Because multiplier has to be times with multiplicand. So multiplicand, it refers to the income, net annual loss, remember the word net, it's not gross. The opposite will be gross. So net annual loss of whom? Of the plaintiff. So it means this is plaintiff annual, not monthly income, annual income. And then we cannot take gross because what? It will because we have this, minus deduction. There will be deductions. For example, there will be deduction for income tax and deduction for living expenses. That's why at the end of the day, the amount will be net rather than gross. And then just now, coming back to multiplier. So multiplier is mainly based on the plaintiff remaining years of working life. But of course, it will be lower. In practice, multiplier tends to be lower than that because it is reduced. Why is that so? Why 16? For example, the age is 30 when the accident happened. And usually the normal people would work until 60. So 60 and 30 years to work. But then multiplier for the purpose of calculating LOFE would be 16, not 30. Why is that so? So this is some of the reason. It is reduced to take account of contingencies, or we call it vicissitudes of life, variation, because nobody can tell what will happen in the future. What if the plaintiff actually, after a few years of working, he died, premature death, or even he lost his job, or he became ill and cannot work? That's why we cannot give the full 30 years. So the court, the law fix it at 16. Meaning here we take into account everything, so that 16 is fair. To award or to calculate the amount of future earning, loss of future earning. That's the rule. Okay, just now, we have read just now to AC one just now. If plaintiff, what if plaintiff has reached 60 years old? Because the claim is only allowed up to 59 years old. If the plaintiff is already 60 years old at the time of the injury, at the time of the accident, there will be no LOFE to be awarded. Of course, he can claim for other types of damages, but cannot claim for LOFE. LOFE maximum age allowed is 59 only. Because we presume people will work until 60. Even not many will work until 60, or maybe civil servant. Even myself, I signed when I joined as a lecturer. I just signed until 58. Because if you want to extend to 60, you have to sign another agreement. So I didn't sign. So inshallah by panjang umur, at the age of 58, then I have to what's the word? Retire. Retire lah. All right. Okay, now we go to multiplication. So multiplier is quite straightforward because if 30 and below 16, if more than 30, then you just take 60 minus the age and then divided by 2. So you get the multiplier already. But for multiplicand, now we want to know what's your net annual income. So usually it is based on salary. And this salary, it has to be legal earning. It cannot be illegal earning. If illegal, of course, the court won't allow the claim. So we're going to look at the case of Chua Kim Swan, and as well as the case of Sukatno. And then for the definition of legal earning here, we have section 28 2C. After this, we are going back to Civil Law Act. So under clause A, under Roman, here, the first clause, it talk about earning. We are going to discuss the case of Dirk and Tan Kim Chuan. So we have quite a number of cases to be discussed today. And then the court is also not allowed to speculate increment. You cannot, plaintiff cannot simply, oh, court, after 5 years, actually, I will get increment 1,000. So can you speculate that? If it's merely speculative, then the court won't allow. It won't be part of the multiplicand. So we have the case of Cham Yun Feng. And also deduction of living expenses. What amounts to living expenses. Not everything will be deducted. Otherwise, the net annual income will be zero, because most people will spend the whole thing. You just save a little bit of your salary. So that is not the way, okay, to calculate or to determine multiplicand. Okay, we are discussing multiplicand. Okay, we go to section 28 to see first. We have to change the screen again and again. Okay, to see. Okay, just now to D kan. All right, to see. Now to see. 28 to see. It has 1, 2, 3. Okay, here. All right. Roman or clauses here. So in awarding damages for loss of future earning, okay, the court shall take into account. Okay. All right, in the case of plaintiff who has attained the age of 60 years or above, okay, 60, 61, 62, okay, no damages for such loss shall be awarded. That's the rule. And but again, there is actually exception here, okay, or in any other case, damages for such loss shall not be awarded unless, okay, unless plaintiff can really prove. It is proved or admitted that the plaintiff was receiving earning. Mean that here, even at the age of 60, plaintiff was still working. So that one the court might allow. Okay, the court may allow the claim for LOFE, but generally no lah. All right. Okay, number 2. This is to determine, okay, the multiplicand. Only the amount relating to his earning, okay, salary at the time when he was injured, will be calculated lah, okay, will be considered, and the court shall not take into account any prospect of the earnings being increased at some time in the future. So prospective, okay, is not good enough lah. You expect to get this increment in 1 or 2 years time. That one is considered as prospect, okay, prospective increment or speculative basically. Okay, that one it won't be part of the multiplicand. And then number 3, another factor, any diminution of any such amount as aforesaid by such sum as is proved or admitted to be the living expenses, okay, at the time when he was injured. So mean that here the court also will look at the living expenses. Okay, I mean the rule here is not so clear, so we need case law to explain. I mean application, how do we apply, how do we calculate? So we have a list of cases to interpret this particular provision. So we have 28 to see 1, 2, 3 Roman. Okay, now we go back to the slide. All right. Okay, we want to discuss the case now, all the cases, so that we can see clearly the how to calculate. Okay, all right. So this is the calculation. Multiplier, okay, it refers to number of years purchased. So it depends on the age lah. Okay, and just now we have read section 28 2D. And of course, it is simpler, okay, if the plaintiff 30 years old and below, so automatic multiplier will be 16, and this is the maximum. But if plaintiff is 31 to 59, okay, multiplier will be 60, okay, minus age at the time of accident, and then divided by 2. So it's slightly longer calculation compared to if plaintiff is 30 and below. Okay, and in order to award LOFE, so we need to times, okay, multiplicand with multiplier. So this is example, okay, hypothetical example here. For example, the plaintiff was earning 1,900 as salary, and he was expecting to get 100 ringgit Malaysia real increment. Maybe next month, or he received a letter already, or maybe employer testify, yes, I'm giving him increment starting next month, for example. So this is what we call as real increment, not merely speculative. So eventually his total salary is 2,000, but still this is gross salary. So how do we get the net annual income, net annual salary? So we have to deduct, okay, you can see the word dash there, okay, deduct minus living expenses. For example, he spent for living expenses 400. Okay, we haven't discussed thoroughly, okay, what is the meaning of living expenses. And then income tax. Okay, income tax usually almost all, okay, almost all person who are working, okay, in Malaysia, we have to pay income tax. That's specific calculation. Usually it is paid monthly by way of monthly deduction. Okay, so income tax monthly here 70 ringgit. But actually, this is quite misleading because in Malaysia, we have a salary, certain salary only, then you have to pay income tax. I think if the salary is 2,000, then you don't have to pay income tax in Malaysia actually. I think your salary has to be almost 3,000, then only you have to pay income tax. It's certain minimum annual income, all right? Okay, so the total net income here eventually is not 2,000. Okay, the gross salary is 1,530 after we deduct, okay, 400 and we deduct 70 as well. Okay, so eventually multiplier is 16, okay, because plaintiff is the age is 24. So now we have multiplicand, and this is the monthly salary. Remember, it's about multiplicand is supposed to be annual, okay, so it has to be times with 12 to make it yearly, annual, and times with multiplier 16. So eventually, the amount of LOFE is almost 300,000 here, 293,760. Remember, LOFE is only allowed if the plaintiff cannot work at all after the accident. I mean, for example, bedridden or maybe become disabled, so cannot work. Okay. All right, and then on top of LOFE, okay, Mr. X here at the age of 24, he can still be awarded with general damages, okay, pain and suffering, loss of amenities, whatsoever. Okay, that one, for example, the court allow 200,000, and special damages, for example, the cost of medical bills or maybe artificial limb or maybe a wheelchair or nursing care whatsoever. So that was 60,000. So altogether, the amount of compensation is almost 500,000. Okay, 500,000 lah, more or less here. Okay, but still it won't replace your normal life. But still, I mean, compensation is allowed, okay, to the plaintiff who cannot work anymore. Okay, no longer can work lah, working. And then under section 28A, okay, of Civil Law Act, it provides for non-deductible sums. Meaning that here, certain sums we cannot deduct from the net annual income. Okay, meaning that here, that's why it has to be certain reasonable, decent amount. Okay, because certain sum it is non-deductible. It won't affect, okay, the amount, the claim, the total amount of multi-applicant. Okay, we go back to section 28A1. Okay, we have read to C2D just now. Okay, we go to A1. Sorry, we have to keep on changing the window. Otherwise, I'm afraid you don't have time to look on your own. Okay, so we look together. 28.1. Okay, just now 2, so 1 here. All right. That's why the word used here, in assessing damages recoverable in respect of personal injury, okay, which does not result in death. So there shall not be taken into account. Meaning that here, this thing won't be taken into account, won't be part of the calculation, won't be part of the deduction. The first one, A here. Okay, any sum paid or payable in respect of personal injury under any contract of assurance or insurance. So whatever things you receive under insurance, it won't affect the amount that you are receiving from the defendant. Okay, and number 2, pension or gratuity. I mean, it won't affect, okay, the amount to be paid by defendant. And C here, any sum which has been or will or may be made under any written law relating to payment, compensation, any benefit or compensation under Perkeso, okay, SOCSO, under Workmen Compensation Act. So it won't affect the amount to be paid by the defendant. Because all this thing here, it depends on the type of victim, because not all victim will receive this compensation under Perkeso, okay. Not all victim has pension or gratuity, okay, especially if the plaintiff is from private sector, okay, not civil servant, okay, or even plaintiff doesn't have any insurance, okay. Not everyone has insurance, or even if the accident happened, sometimes insurance company doesn't pay because of certain reasons, okay. All right, so this is all we call it under non-deductible. It won't affect, okay, it won't be deducted from the amount of LOFE. Okay, right, so we have discussed 1, 2, 3 just now. Okay, example number 3 just now, C, and just now we use, I mean, in the provision it use C. So any sum paid or payable relating to benefit or compensation of under any written law. For in Malaysia, we have SOCSO, or in bahasa we call it Perkeso, okay, Pampasan. I mean, the organization, okay, the body which, I mean, which take care, okay, of especially those who are working in private sector. And Workmen Compensation Act. Okay, we go to the case to to explain about non-deductible just now. So this is the case decided by Supreme Court in the year 1991. The case name is Ward. Okay, that's the name, okay, of the plaintiff, Ward, Mr. Ward, and MAS, okay, Malaysian Airlines and System Berhad. So this is appeal case. So who was the appellant? The appellant was a pilot, and he suffered injuries due to emergency crash landing, okay, of the aircraft. And when the case went to the court, okay, the damages assessed, the amount was 301, okay, 1,250, okay. And then trial court in this case said, well, you have received the insurance 300,000. So basically the defendant just need to pay you 1,000 only, 1,250. So the court deduct lah, so that you won't, so that the appellant won't receive twice the compensation. Okay, that's what the trial court said. But on appeal to Supreme Court, okay, Supreme Court said that no, okay, insurance benefit won't be deductible. This is something different, okay, different compensation altogether. So of course, in this case, appellant was entitled, okay, for the full sum of 201, 250. Okay, this one from his employer lah, okay, from Malaysian Airlines, together with the insurance that want to be paid from by insurance company. So from two different sources, okay, two different parties here. In respect of illegal earning, okay, section 28A to C, okay, you can have a look later. We have the case, at least two cases here. Okay, we have Chua Kim Swan, okay, which concerned with illegal taxi, not really illegal taxi, but taxi without permit. Okay, and then we have Sukatno, and this is about illegal worker, no permit lah. Basically, cannot produce evidence that he was working legally. Okay, for Chua Kim Swan, another judgment by Supreme Court in year 1994. So the main issue which concerns us here is whether a claim for loss of earning, okay, obtained from illegal source could be entertained by the court. So what does make, why the source, why the income was considered illegal here? So the court held that any claim for loss of earning, okay, from illegal source, so as far as the case was concerned, it's about income, okay, earned by the deceased in running a taxi. So he was the taxi driver, but he was killed, he died, okay, in running a taxi which was not licensed in his name. So there's illegal part here, illegal element. He doesn't own the taxi, okay, he ran it without a permit lah, basically. So it should not be allowed. Okay, what's the ground? On the ground of public policy. If you allow this claim, then there will be many claims lah. People can simply do the things without properly asking for license or asking for permission whatsoever. Do it properly according to the procedure. That's why the court doesn't allow the claim. It is considered as illegal source, non-compliance with the law. Okay, in Sukatno, okay, the full name of the case is Lee Senki and Sukatno and another 2014 and judgment by High Court. Okay, so plaintiff claim, one of the claim, okay, by plaintiff was for loss of earning, but the court said no. Okay, we cannot award. Okay, because why? From the evidence, okay, when the accident happened, okay, the plaintiff was working illegally, okay, in the country at the time. Why he was considered as working illegally? Because when the court asked for all the document, he couldn't produce it. Okay, plaintiff failed to establish, okay, on balance of probabilities that he had a valid work permit. Okay, and then also he cannot really prove to the court, oh, I'm getting the work permit shortly. No work permit at all. So he was working illegally. So whatever things happened to him, cannot claim. Too bad lah, basically. Okay, because the claim cannot be based on something which is illegal, cannot be based on illegal earning. Okay, that's about it for legal or illegal earning here. Okay, now about speculation, increment in the salary. Okay, the case, the specific case here, in order to help with the interpretation and to show the application, Chang Ming Feng and Jackson Lim, okay, that's the name of the case, reported in the year 1999. And then in this case, the court held that, we have read the case just now, okay, the provision just now. The court said, well, this part of the act, it make it clear that the court must not speculate. Okay, of course, the court should not ignore the reality of the situation. Okay, where the respondent's basic salary has been increased at the date of the trial. So in that case, if there is a real increment, okay, for example, the trial will usually prolong. Okay, you will I mean it consume time between 2-3 years. Okay, within the 3 years, so salary was increased. I mean that one is actual increment. So the increase is actual and not prospective in that particular case. Okay, so the act does not prevent the court from taking into account actual increase, so long it is not merely speculative. It's not prospect of increment. Okay, actual increment will be taken into account as part of the net annual income, okay, as part of the multiplicand. Okay, we have 10 minutes left. Okay, and this is I mean further elaboration. Okay, discussion speculative versus real increase. So of course, from the case Chamin Feng just now, the court, what's the court's duty now? What's the court's discretion? The court is not allowed to speculate. Okay, I mean the court simply cannot say, oh yes, we agree. Maybe after 5 years your salary will be double, for example. That one is merely speculative. We cannot tell okay what happened in the future. So increment must be real and not speculative. Okay, real here, it must be supported with documentary evidence, okay, salary from the employer, okay, or maybe salary slip, or maybe testimony. Okay, the employer stand as the eyewitness to testify. Yes, I'm giving him after 1 year. Yes, the company will definitely increase his salary. For example, okay. I doubt okay, employer will come and testify for employee, can, especially to increase the salary. All right, and this is discussion on living expenses. Okay, remember, in order to have a net annual income, okay, I mean there must be certain deductions. Okay, deduction of income tax. That one is easy to calculate. Okay, that one payable to government. Another deduction is deduction of living expenses, but not all living expenses. Otherwise, it will be zero. Okay, the salary, the net salary. Okay, the important case here is Chang Chongfu. Okay, I mean, you have so many cases with a Chinese name, so be careful. Okay, Chang Minfeng, Chang Chongfu, whatever names here. Okay, Chang Chongfu and Sivanathan, another judgment by Supreme Court in year 1992. So in this case, plaintiff was injured in an accident, and then in his evidence, okay, take note, it happened in before year 1992. That one is the report. Okay, so in his evidence, he stated that yes, he spent 60 ringgit per month, okay, on petrol, okay, those days. Okay, petrol 60 ringgit is enough, and meal per day 5 ringgit per day, especially the one that he bought when he was at the workplace lah. Okay, 5 ringgit per day for food, and then defendant submitted that, the one who is supposed to pay, defendant, okay, defendant submitted that yes, these living expenses should be deducted. We are not paying this 60 plus 5 here. Okay, it has to be deducted from the gross salary. Okay, so the court agree? Yes. Okay, the court ruled in favor of the deduction, and in this case, all right, very important because this is interpretation, okay, case law interpretation. The court define living expenses. It is very narrow. Okay? We cannot include everything into living expenses. So the court define living expenses to include only petrol, okay, because you need petrol to go to work. Petrol and also meals at the workplace. Okay, not meals at home, not meals on the weekend, meals at workplace only, because that one you need to spend in order to get your salary. Okay? And then maintenance of vehicle to go to work, or even if you don't have your own vehicle, you pay for taxi or bus fare. So only this thing is considered as living expenses for the purpose of calculating net annual income. Okay, what if you spend for your gym, okay, for your sports, for your hobby, or you spend for groceries, you spend for clothing? Usually that one is not part of living expenses. Meaning that you can claim from the defendant for that part. It's not part of the thing that you spend in order to earn, yeah, or related to your work. Then yes, it will be deducted as part of the living expenses. Okay, so the word living expenses here, it has very special definition or interpretation. Okay, so coming back to Chang Chongfu case just now. So from the gross salary, so gross salary is 310 ringgit. Okay, don't ask me why so low. That one is in year 1990s lah. Okay, 310. So from the gross salary, the living expenses has to be deducted. So the court deduct transport, the court deduct snacks at the workplace, and the court also deduct cigarette. Okay, even though this one it is open to criticism, kan? Cigarette here, is it related to the work, or you smoke at workplace? Okay, that one. But in this case, the court allow for deduction for cigarette. Okay. But let's say we don't have any evidence, okay, to show, how much amount to be calculated for the deduction. Another approach by the court is that, okay, sometimes in some other cases, the court simply deduct 1/3. So 1/3 is considered as part of the thing that you spend in order to earn, okay, your salary. Okay, that one is straightforward lah. I mean, you don't have to deduct one by one. Okay, you just take only 1/3 deduction. So net income would be 2/3 of the salary. If salary 3,000, so net income will be 2,000. That one is straightforward, simpler. But if you can prove to the court, if the plaintiff can prove to the court, so the defendant will usually argue in favor of the deduction one by one lah. Okay, all right, it depends. So in this case, defendant solicitor was arguing, okay, that the gross income RM 310 of the plaintiff should not be used as the multiplicand because there should be deduction. Okay, cannot take the gross income to be the multiplicand. And Supreme Court Judge Harun Hashim, he agreed. Okay, so the court deduct 60 per month, and the court deduct 5 times by 26 days, okay, of working days. For food, okay, in the year it becomes 190. So now multiplicand will be 310, okay, gross salary minus 190. Okay, it becomes 120. Very small amount lah, the net annual income kan. Alright. So eventually, what is the amount of LOFE in this case? 120, okay, times by times by the months, okay, the multiplier. Okay, multiplier is 192 months lah. Okay, that one is months. If you divide it by 12, then you have the years lah. Okay, but in this case, the court make further reduction of multiplier. Okay, even though from the statute, okay, like the one that we read together just now, it has to be 16. Okay, but in this case, the court used further discretion, okay, to reduce the multiplier, so it becomes even lower. Okay, it becomes smaller here. Okay, it reduced by 20 months. But in some other cases, this case has been criticized lah, because it is stated that, it is argued that the court doesn't have discretion to deduct or to reduce, okay, the fixed multiplier. But in this case, the court simply use all the discretion. And maybe the defendant really make a strong argument or convincing argument. So that's why the court ruled in favor of deduction of multiplicand. That one understandable. But deduction of multiplier as well. Okay, the fixed one. But this is what happened in Chang Chong Fu. Okay, another, I think, okay, we have 2 minutes left, never mind. So another factor, okay, that in order for the plaintiff to be able to be allowed to claim LOFE, okay, it must be proved that he was receiving earning at the time of the injury. Okay, for example, in the case of Dirk, okay, Dirk and Piternala Halma, this is a nurse from Holland, okay, and Muhammad Noor, another case by Supreme Court. So in this case, Dirk, Mrs. Dirk here, she was a nurse and she was on unpaid leave, okay, for 2.5 years. And what's the mission? Okay, she was cycling around the world. But in Malaysia, when she arrived in Malaysia, especially in Ipoh, she was involved in accident, okay, with bus. Okay, so Muhammad Noor is the bus driver, or is he the employer of the bus company? So she suffered serious spinal injury and paralysis. Okay, she became paralyzed of lower limb. Okay, and then injury to bladder and bowel function. In effect, okay, all the lower limbs lah, basically. But in this case, she was on unpaid leave, so there's no salary. Okay, was she receiving earnings at the time of accident? The answer is no, negative. And under Section 28(2)(c)(1), okay, the requirement is that she must be receiving earning, then only she can be entitled for LOFE. So she cannot claim, okay, zero claim for LOFE. All right. But this one we reserve. Okay, I'm going to do record a lecture for LOEC, okay, later, so that you can see the comparison. So in Dutch here, okay, she couldn't claim for LOFE. Why? Because she wasn't earning. Okay, despite the fact that she was earning before she took unpaid leave, but when the accident happened, no earning, okay, zero income, so cannot claim for LOFE. But of course, she could claim. She was allowed to claim for another category of claim lah. Okay, but that one I will explain later. All right, so that's all for today. For this morning's lecture. Inshallah, I'll prepare. Continuation will be done via asynchronous mode. Okay. So, Assalamualaikum warahmatullahi wabarakatuh.